I'm here tonight to ask for your help. As you may be aware, there was an appeal filed regarding the permit that was approved for the Fairway Billboard on Friday. And I know each of you hates the billboards, and so I want to invite each of you to join our fight against them by donating to the Preserve Johns Creek GoFundMe account by going to preservejohnscreek.com. Attorneys will be involved. That's going to cost money. Anyway, unfortunately, despite efforts to stop the billboards, the Georgia Supreme Court ruled that the permitting process denying billboard applications in Fulton County was unconstitutional. Because of the settlement that the city negotiated, we are now in the middle of those billboards going up in Johns Creek. And you know, there has been especially strong opposition to the sign going up at the Fairway, based on many factors like driver safety, the effect on housing values, aesthetics, and especially the encroachment on one of our historic cemeteries. And I can maybe understand why permits were issued at other locations, but I don't understand why the permit was issued at the Fairway. When the parcel was zoned in the early 90s, a condition of zoning was added that allowed retail, service, commercial, and or office and accessory uses, including all exterior food and beverage service areas, but excluding service stations, commercial amusements, and billboards. So billboards were prohibited at the Fairway as a condition of its zoning. I thought that a condition of zoning could only be changed through a zoning application. Can't a zoning application only be approved after going through the open zoning process that's required and dictated by state law? Community development was apparently aware of this prior condition, but Johns Creek has approved the Fairway permit anyway. Again, I'm not pulling any punches here. I am truly kind of at a loss and trying to understand what's going on. And I would understand if the Supreme Court ruling stipulated that its decision nullified all prior existing prohibitions against the billboards. But it does not. It actually says just the opposite. At least 5 different times, the state Supreme Court affirms that all other valid restrictions remain in place. The Supreme Court decision did not nullify any other valid restrictions on billboards other than the permitting process, which they ruled unconstitutional. Therefore, the condition of zoning at the Fairway is still in place and still valid. So, this application in question would not have been legal because there was a condition of zoning that prohibited billboards, which was agreed to by the owner of the property. This was not part of the countywide sign ordinance that was... I've got just a little bit more. Can I finish? That was ruled unconstitutional. At the time the application was filed, the Fairway was not allowed to have a billboard. If you say that the permit was only granted because of the terms of the settlement, then I'm perplexed as to why we agreed to give up our rights within the law to deny this particular billboard. So, with this knowledge, the city needs to rescind its permit immediately unless it can show where the conditions of zoning were removed after public hearings as required by law. If I am missing something, and I might be, please help me to understand and help the rest of us to understand in the community what exactly is going on, because right now it seems that the city is going out of its way to give permission for this billboard at the Fairway. Mr. Mayor, I would appreciate it if you could shed more light on this case. Thank you.